Sometimes I swear these stupid tech issues. My video froze before, and okay, so now we're back with the audio. Everybody can hear that, but it'll all still be in the podcast that we'll get up at markstevens.net. So none of the audio is actually lost, thank goodness. Where was I? Now, you have to find out if one of these attorneys waived your right to a speedy trial. They may have done that because if you're over a year now, then the right to a speedy trial has been violated. They have to get you to trial within either 150 or 180 days. But you got to check to see if the attorney went and waived that. And if they did, then you have a case for ineffective counsel. If you've got the police officer on record testifying or stating in his police report that it was not evading, you should file for a malicious prosecution. They're going against the testimony of their key witness. This is something that should not go to trial. I mean, I know the public defender may feel it's best to bring this up at trial, and you can, but I would do everything, and I think it makes better sense to do everything to avoid the trial. And so if you've got to show that the prosecution is maliciously prosecuting you, they know what the witness has already said, and because they have to, the witness has to have personal first-hand knowledge, and this police officer has already made statements that are against the charge. So why the prosecution bumped it up to a felony is, I don't know. We don't have enough information there. Oh, jeez. Yeah, well, if you did the 8 months for something else, they're not going to necessarily give you credit for it, because but then if they convicted you, you'd be looking at still 3 more months in prison, or jail. Oh man, that sucks. Well, they can't allow. Well, the judge has to accept a guilty plea for them to. They have to be able to accept a guilty plea to, first before the clerk can accept the payment for. This is a mess. I would suggest getting a motion in for prosecutorial misconduct and malicious prosecution. And yeah, the tough thing is that you may not be able to even file your own paperwork as long as there's an attorney attached to this. So if the public defender is not standby, there's not a damn thing you can do to defend yourself. They have to be at least standby so that the judge has no legal excuse not to hear your motion. No. Yeah. Yeah, try to get the standby counsel so you can file your own motions and defend yourself with assistance of counsel the way it's supposed to be. And let me know. Keep in touch. Let me know what's happening. I appreciate the call, Tim. Good luck, and we'll hear from you soon. We're trying to get through everybody so that we don't go over time. Obviously, we're going to have two videos, a part 1 and a part 2. It sucks, but I don't think I can load the video any other way because the video feed did lock up about halfway through the show. So, but we're back, and all right. So we have 2 parts. What? Okay. But we've got more callers. We have Dale in Indiana. Dale, welcome back to the No State Project. What do you got for us today? Oh no, you terrible person, you.
Filed the motions like you said 10 days prior. I had made sure that I had a copy sent to both the police officer and the prosecutor, and he said okay. So he stopped him, and he read through both motions. I filed two motions. One was for the discovery and the Brady request, and the other was the to strike and dismiss the complaint. And so he's reading through, and by the time he gets done, about 15, 20 minutes past, he kind of looks up and he looks at the prosecutor and he starts asking her a whole bunch of questions. And she, like who's her witness? Who's going to be her expert witnesses that the laws apply? What evidence is she bringing forth? And she just kind of was stunned, didn't really have an answer. And then the judge had asked her, did you read his motions? And she said, I went over them. And he interrupted and said, did you read his motions? And she said, no, Your Honor. And he goes, I suggest you do so.
Nice.
And so we took a recess of 15, 20 minutes so she whatever can go through it. And then she comes back and she hands me a copy of the citation from the clerk's office. She hands me a copy of the supposed police report from the police officer of the incident, the stop. And so we come back and he starts asking her questions, and he asked her how long does she think that it's going to take for her to be able to gather all this information. And so she said 30 days, Your Honor. And so
the correct answer was never.
Say again?
The correct answer was never.
Right. And so he said, okay, so this court date set up for the 22nd of December. And he looks at me and he said, is that all right? And I said, well, I object, Your Honor. And he's like, well, what do you mean you object? And I said, oh, I filed the motions like everything that you had said, and I want to, get the second motions heard. And he said, okay, well, this is my opinion. And I said, okay. He goes, it's my opinion. You filed your two motions, the first one being the discovery and the Brady request. I think it would only be fair to allow them to have the opportunity to respond. And I said, I can agree with that, Your Honor. However, I thought the whole point of my filing the motions 10 days prior and making sure that they got a copy of it was so they could be prepared for today. And the fact that they're not prepared today is why I'd like to have the second motion, heard as well. And kind of looked at me and gave his opinion again. And I said, all right, I understood what he was getting at, and I feel I won't go there. And so we have the hearing on the 22nd of December, and what the judge expressed to me, because that's what it was. I had used your guilty plea to plead guilty today, but if they had the evidence, I would plead guilty, so I want to resolve this threat of violence against me today. I had to go through it before, and then I'm still on it today, which is why I'm here. And then now, you're expanding it to another date in the future. And he goes, well, I appreciate you being here. However, again, it's my opinion that we should give him this opportunity. And I said, okay. we'll move to the 22nd. And he had clarified to me that for the prosecution to respond to my motions, they have to send me personally to my house the evidence that they intend that's within asked within the request, the motion. And so I said, okay. So if they don't, and I said, well, what if I don't get anything? And he goes, well, if they don't send anything, you file notice. I said, okay. And so that's where I'm at in this case. And he said, I go in and I'm waiting for supposed evidence to be supported from the prosecutor.
I love when you emailed me what had happened before, and I'm glad you made it to the show and can relate this to us. I love how the judge. Did you read it? And
Yeah.
So for those people who would say that there's no merit that to it's something like the motion to dismiss or the discovery request, the judge could have just come flat out and said, if the discovery request / Brady request, which it's more of a Brady request, that's much more important in my eyes. If that had no merit whatsoever, the judge would have just said, this is ridiculous. They're not required to give you anything in here. So.
And see that's my whole argument against like the people that are in my experience. When I tell them that this is going on, they're just like, well, why don't you just get your tags? But it's like, well, why don't you just bend over? Oh, you are. I'm not. I'm choosing not to. This is the principle of the whole idea. This is the whole thing. And my argument is, and why I want to express love for the work that you've done and you've gone through, because I know this wasn't easy for you to get to this point. And I tell people, if I had no ground to stand on, if there was no water for me to swim in, I wouldn't be where I'm at this far now. I mean, yes, I know I'm going into another case but all my questions, all my arguments, the judge would have already thrown me in jail if there was nothing, if I wasn't standing on something solid. And thank you, Marc, for being solid.
Oh, I appreciate that. I did want to point out that Robbie did go to jail, and he was on solid ground. So I think I think the better point is, if in your situation, is the judge would have just said, this is ridiculous. This is legalistic gibberish, and I'm not going to require the prosecutor to have this. That's where I think you show that you do have a leg to stand on, that it does have merit. And I want to point out that a question that we asked the prosecutor or the judge is, in a situation like that, is, are you under the impression that the prosecution has given you evidence to prove jurisdiction to set this for a hearing on December 22nd? Then so since you are under that impression, what the hell did he give you to lead you to believe that? Why do I need to wait 30 days until December 22nd? He has to have it now. I'll give him a pass on the witness with personal first-hand knowledge, but you can't give him a pass on the evidence he's supposed to have right now to show a prima facie case to set it for trial. And that is something that the judge got away with, but we know next time you're not going to let him.
Oh, of course. Well, you know what? I think what's really interesting, at least from the experience that I have, like I've prepared myself to go into this as being, brimstone and fire, and having to deal with aggression and having to deal with, just trying to prove power. And this is all played out is completely opposite. It's like seems so far, at least what I've experienced to be as of yet, is that it's like this is like the best example of how things should go. Because the judge is actually taking. I mean, granted, I wasn't able to, get firm, but we're making progress, and I feel like, at least from my reflection of what his attitude and his action and seeing her response, because she was in the middle of being questioned, she's fanning herself off with her papers instead of the writing that she was doing the whole time the judge was reading. Because she wasn't doing anything but filling out papers, and then when he starts asking her questions, she's fanning herself off. So it's like, yes, this is what we need to see. Sorry.
Well, yeah. Well, that's fine. I agree. And what I would just add is that what you're doing is sort of rare. in that you are the judge is actually holding, at least for appearances, is holding the
Mm-hmm.
prosecutor to their burden. And yeah, he gave him an extra 30 days, but there's no way they can comply. So I think it is very significant here. Yeah, I know it's traffic, but whatever. I don't listen to the critics. You can go to jail here for this. So that's not,
Yeah.
that doesn't defeat the argument or the claim. It's significant because the prosecution is actually being held to a burden of proof, which they're not used to. As like you're saying, they don't seem used to it because in traffic, they're almost never held to their burden of proof. They can do literally whatever the hell they want, and the judge is just a rubber stamp. Whatever, okay, prosecution, okay. Oh, the prosecutor said legalistic. Oh, yep, no, we'll take it. We'll take it.
And what was funny was in the little period of time, the judge had allowed the prosecutor to talk to me, and I've come to the understanding that when that happens, the record's always on. So so I brought all the motions, and I had all the motions in my hand, and I even had the guilty plea, unsigned guilty plea. I had it in my hand, and I go up to her, and she says, "Did you get your sticker yet?" And I said, "The sticker." She goes, "The sticker for the license plate." And I said, "No." She goes, "Well, if you just got the sticker, we'd drop the case." And I'm thinking to myself, yeah, and I told her, it's like, yeah, but I'm waiting for the outcome of this case before I would even decide to go get a sticker because, and she's like, "Well, we have jurisdiction." And I'm like, "Well, then where's the evidence in my motions?" And she just kind of got all flustered. And then she's like, okay, I know what you're doing. She goes, "I've been doing this for, what'd she say? I've been doing this for 17 years. We've got the jurisdiction." And I'm like, okay, well, then why aren't you answering my motion?
Where is your proof, and who is the witness with personal first-hand knowledge of it? It's not rocket surgery here, lady. If we already know you have a claim, we know that you think this claim is absolutely true, as if from Zeus himself. I understand that. Can you prove it? That's why we're here. That's what a trial is. That's what a trial is supposed to be about. Can you prove it? But the best they can do is, I don't have to.
Yeah.
You criminal, you. Hey, she said she needed 30 days to provide that. Should have been in the file already. In the damn file. So, well, look, we're almost out of time here, so I'm going to try to grab a few more calls. I appreciate the call, Dale. Definitely keep in touch and call in again maybe before if you hear something from the prosecution. I would be prepared with a motion to dismiss for prosecutorial misconduct. I'd have
Absolutely.
that.
I'm going to have that prepared and filed, ready to go.
Sounds good. All right, my friend. I appreciate the call.
Peace, love, namaste.
I'm sorry?
Peace, love, namaste.
Yeah. Right back at you, tough guy. Appreciate the call. Dale in Indiana. Actually having a judge holding the prosecution to some of the rules. Have you read this? How much time do you need to comply? Hey, that's if you've ever been in a traffic situation, you know that is not very common. Not very common at all. Holding a prosecutor to their burden. They don't give a damn about Brady requesting a traffic ticket. What Brady? What the? Oh, please. All right, we're going to do our best to get to a couple more calls over here. We've got DF. I think I got that right, from Louisiana. Welcome back to the show.
Yeah, Mark, good memory. Thanks.
No, it's not memory, my friend.
Okay.
It's just a program I'm looking at right now.
I gotcha. So the reason why I was calling is because I meant to get in on that call you did with Robbie and Joe, and you didn't end up having time to bring me on. So I just wanted to add my little piece to it and let you know that we were able to bail Robbie out of jail within about 26 hours or so, or maybe it was 2 days. But we got him out. His bail was $2,000. And then I put up the money for that, and James helped out to actually, get the process done locally there. And since then, we have raised $1,331 and change altogether from, I think it was 14 donors from our group.
Wow. Well, my hat's off to the group. I really appreciate that. I mean, we do a little show here but it helps a lot of people. And for the guys to come together that way and to help somebody out who they've never met before means a lot. It means a lot. We can't proclaim that we've got the largest podcast in the world, but damn it, people have come through here for Robbie, and that is appreciated. If I had any means, I would have helped, but you can all see how we do the show here. It's not a matter of we don't have an influx of cash like some shows. So, but bravo, I appreciate that.
Yeah, well, that's okay, Mark. You're doing your part every week. You got your show running, and you're informing people about all this stuff and helping a lot of people. So we really appreciate what you do.
Well, thanks, and hopefully we're going to get a good resolution for Robbie in this. I would suggest, and I've mentioned it before, some of the motions that would need to be filed here is we definitely have prosecutorial misconduct. Well, you always do. We definitely have a judge who is totally, almost completely unhinged to even hold him for a bail on something like this, and to say that Joe's phone call was a threat to his family is just beyond the pale. That either there's one or two things that are going on. One, he is a criminal who's got an anger management problem, or two, he's legally an idiot who really doesn't understand what constitutes a threat, or he's just a lying scumbag. Which Angel Lopez, yeah, I'm going to have to side with lying criminal. That's what he is. He knew what he was doing.
Yeah.
Joe's call, we heard it. Joe's call could in no way, shape, or form be considered a threat, especially not, and to extend it to Angel Lopez's family. He was talking about Angel Lopez going to prison for his crimes, which we can prove beyond any doubt whatsoever, and he didn't mention his family at all, other than if they Googled him. What, is Google some kind of ISIS code word now? Give me a break.
Well, yeah, and not only that, but then to go and take that, even if he could take it as a threat, and then to somehow juxtapose it onto Robbie was just absurd.
Oh, connecting it to Robbie was absolutely insane. Absolutely insane. Does he have a phone record that connects Robbie to Joe? Please, gather your friggin' evidence before you make your accusations. Look what I'm talking about. He's a lawyer. Lawyers they get the facts to fit the theory, not the other way around. See, in science, it's let the data speak no matter what the data says. But with attorneys, with cops, let's say this is what happened and then get the facts to fit that and do it backwards. Or, here's another thing they do. Don't worry about the facts. We're Odin's and Zeus, we're his servants. We don't need evidence. So just throw rational thought right out the window. Hey, because when you have a prison system, you don't need to have evidence and logic behind you. You don't.
Well, yeah, and this is case study number one in that, I guess, at this point.
This is a big one. So, yeah. Well, thanks. I appreciate it. I really do. To you, everyone else that stepped up and helped Robbie out, I appreciate it, and it shows that you don't need to have the largest podcast in the world or even in North America to be making the difference. And so we're using logic and reason, rational thought, and making it a moral issue, making it a moral and standing on a moral principle. And using the Socratic method to show that they are not being moral, that their position is untenable, and there's a lot of merit to that. Even again, we don't have the size, so again, my hat's off to you and everyone. I appreciate you guys helping out.
Yeah, thanks, Mark. And hey, I just want to take this opportunity to plug the Skype group. If for the people who are listening, this is. I'm not saying we're going to bail every single person out of jail, right away, but we do have a really strong community here, and this is, just one more reason to be a part of it. And for anybody who wants to do role play or spend more time learning about these issues and have live conversations about it, we run calls pretty much every night. So, for the people that are listening, they should get in there.
We have Mark. You have markstevens.net. There is the upcoming events where on Skype you just hit the upcoming events, the link there, and that'll bring it to you. Someone calling now. So,
all right.
And then you can contact me at frankrizzo3 and then I can put you into the No State Project Skype chat. And I should have mentioned to Tim in New Jersey to definitely contact us. One of those two ways, get into the Skype chat and do some role playing, and that's really going to help you prep for court. So I appreciate that, DF, for reminding me.
All right, thanks, Mark.
All right, thanks, DF in Louisiana. Appreciate the help with Robbie and with all the role playing. That is definitely appreciated. We get one last call here. We've got a Skype call. Looks like. What's your? You're live on the No State Project. What's your name? Where you calling from? Hey, you're live on the show. What's your name? Where you calling from? Damn it. All right. Well, I don't think we're going to be able to get that call, so not happening today. But we are pretty much out of time. This is the third edition of the No State Project, live on Wednesdays, and we'll have this up in a two-part episode, though, on markstevens.net. Also, we'll have it, of course, on my YouTube channel. Oh, yeah. I guess we have a little bit of music that takes us out. Again, this is my good friend Chris Case. And the band is Double Bucci. Just a force to be reckoned with in Key West. Great, great band. I need to get that all posted up on YouTube so that more people can actually hear that and check that out. But it's Chris Case and Caffeine Carl Wagner. Two great guitar players and some of my favorite music. In fact, a lot of Adventures in Legal Land was written to this CD. So just a ton of really good stuff. So yeah, that's what. To sign off here again. Remember, we do the show live here every Wednesday at 6 p.m. Eastern Standard Time. And also the regular live broadcast on LRN.FM. The Liberty Radio Network is every Saturday from 4 to 7 Eastern Standard Time on the Liberty Radio Network, LRN.FM. Okay, my name is Marc Stevens. Till next time.